Starting with Cox Communications versus Sony, the billion-dollar battle over copyright infringement and piracy. The justices seemed genuinely troubled by the predicament. As Justice Sotomayor put it, the parties placed them in two extreme scenarios. On the one hand, Cox claims they possess no way to identify specific copyright users within a household or sometimes a building or region. If they face liability, they'll have to kick off innocent users. On the other hand, Sony claims that Cox will never receive incentives to remove known copyright infringers, which would allow piracy to flourish. The court's primary focus centered on the standard to hold Cox liable for users' copyright infringement. Does it suffice to simply know that users employ your service to infringe, or does Cox need to take additional steps to facilitate infringement beyond simply supplying internet services? Sony's lawyer, Paul Clement, advocated for the common law approach, which allows for liability when taking an act knowing that certain results become substantially certain. However, as Justice Kagan and others countered, this conflicts with recent Supreme Court decisions that squarely reject this substantially certain approach in a related area of social media company liability for user criminal conduct. Fun fact, Paul Clement helped convince the justices to reject the substantially certain approach. Ultimately, I think the justices may lean into the court's recent cases and rule in Cox's favor. The court trends away from expansive liability, particularly given that the statute Sony sued under does not explicitly state that internet service providers can face liability. Their answer, they'll say, directs Congress to write a clearer statute that authorizes liability against Cox,